You're driving home. Red and blue lights flash behind you. You pull over. The officer walks up, and here's what catches you off guard. He's smiling, friendly, almost like an old buddy. "Hey there, how's your evening going?" And every single day, drivers make one costly mistake. They smile back, they relax, they start talking. That smile isn't friendliness. It's a documented psychological tactic called rapport-building, and it's the first step in an interrogation technique that extracts confessions from people who had no intention of admitting anything. After analyzing over 400 traffic stop body cam videos and studying police training manuals, I've identified exactly how this tactic works and the 5 exact phrases that shut it down before you hand them evidence. I'm going to show you the 5 critical sentences that protect you when an officer uses charm as an interrogation tool. This is educational content only. For specific legal guidance, justification fee is and consult a licensed attorney in your jurisdiction. Phrase number 1 is, "Am I free to leave?" Picture this. The officer leans against your car, smiling warmly. "So where are you headed tonight?" The mistake most people make is assuming a friendly officer isn't interrogating them. They think casual conversation is harmless. Wrong. That smile is trained behavior designed to lower your guard. Research from the British Psychological Society shows confessions are 14 times more likely when officers use rapport building. The legal reality under Salinas versus Texas: anything you voluntarily say before invoking your rights can be used against you in court, even if you were never arrested. The Supreme Court ruled 5-4 that silence alone doesn't protect you. You must explicitly invoke your constitutional protections. Body cam captures everything. Your casual admission that you had a couple beers at dinner creates a timeline and gives prosecutors exactly what they need. The officer knows this. The smile is the entry point. Once you start talking, they guide the conversation toward incriminating information. Training manuals teach officers to use smiles and friendly small talk because it disarms suspects and increases disclosure rates by 400%. The officer psychology reveals that rapport building is the foundation of the Reed technique, a psychological interrogation method used nationwide. Here's what actually happens. Officer asks, "Where are you coming from?" You answer, "Just left a bar downtown." The officer nods, still smiling. "Oh yeah, which one?" You name it. He asks what you drank. You say 2 beers. He asks what time you left. Now he's got your alcohol consumption, your timeline, and witness location. All while smiling. That's 3 pieces of prosecution evidence from one friendly question. The correct move. The moment the officer asks anything beyond license and registration, you say these exact words. "Officer, am I free to leave or am I being detained?" Say it calmly, politely, but clearly. This forces the officer to clarify your legal status. If you're free to leave, you can go. If you're detained, you invoke your other rights immediately. Why this works? It takes control before the rapport-building tactic can take hold. It signals you understand your rights. Legally, it forces the officer to state whether you're under investigation. Officers don't like this question because it ends the casual interrogation phase. Wrong approach. Officer smiles and says, "How's your night going?" You say, "Good, just heading home." He says, "Where from?" You say, "Friend's house." He says, "Oh, nice, been drinking?" You say, "Just a couple." You're now 5 exchanges deep and admitted alcohol consumption without realizing you're being interrogated. Right approach. Officer smiles and says, "How's your night going?" You say, "Officer, am I free to leave or am I being detained?" He says, "You're detained for the traffic violation." You immediately invoke the next protective phrase. That's the bottom line on establishing your legal status. But knowing you're detained only protects you from continuing the conversation. Under Salinas versus Texas, you must explicitly claim your Fifth Amendment protection, not just stay silent. Silence can be used against you in court if you don't invoke the right first. Phrase number 2 is how you do that without giving prosecutors ammunition. Phrase number 2 is, I invoke my right to remain silent. The officer keeps smiling even after you ask if you're free to leave. He says, well, you're detained for speeding, but I'm just trying to understand what happened. You seem nervous. Everything okay? The mistake people make is staying silent without explicitly invoking the Fifth Amendment. Why? They think silence is enough. It's not. The legal reality from Salinas versus Texas. The Supreme Court held 5-4 that if you remain silent without explicitly invoking your Fifth Amendment rights, prosecutors can use that silence against you at trial. They can tell the jury, notice how the defendant went silent? That shows consciousness of guilt. The evidence problem. Body cam shows you stopped talking when asked a critical question, and prosecutors argue your silence proves you knew you were guilty. That's admissible under current law. The officer psychology. They're trained that if you just go silent without invoking rights, they can keep asking questions, and your silence becomes evidence. But if you explicitly invoke the Fifth Amendment, they must stop questioning or risk Miranda violations. Here's the realistic exchange. Officer says, you seem nervous. Why is that? You say nothing. He waits 10 seconds, 20 seconds. Body cam records your face, your discomfort. He tries again. If there's something in the car I should know about, now's the time. Are you carrying anything illegal? More silence. He notes in his report, suspect became silent and evasive when questioned about contraband. At trial, the prosecutor tells the jury, an innocent person would have simply said no. Watch what the defendant does instead. Your silence, without invoking rights, just became evidence of guilt. The correct move, when detained, and the officer asks any question beyond standard traffic stop procedure, you say, I am invoking my right to remain silent. Say it once, clearly, calmly. This is the magic phrase from Salinas. Why this works legally. Under Doyle versus Ohio, once you invoke your right to remain silent, your subsequent silence cannot be used against you. Period. Prosecutors cannot comment on it. The invocation creates a constitutional shield. Tactically, once you invoke, officers must stop interrogating you. If they continue, anything you say can be suppressed. If the officer pushes back with, if you got nothing to hide, why won't you talk to me? You respond with the same phrase. I am invoking my right to remain silent. Do not explain, do not justify, just repeat the invocation. Before invoking, officer asks, where were you tonight? You stay silent, he notes. Suspect refused to answer basic questions, demonstrating evasive behavior. The prosecutor uses this at trial. After invoking, officer asks, where were you? You say, I invoke my right to remain silent. He stops. His report says, suspect invoked Fifth Amendment rights. The prosecutor cannot mention this at trial. That's the bottom line on explicit Fifth Amendment invocation. You've established you're detained and invoked your right to silence. But those protections only cover verbal interrogation. The Fourth Amendment requires separate protection for physical searches. Without the next phrase, officers can still search your car. Here's what stops them. Phrase number 3 is, I do not consent to any searches. The mistake is thinking your silence also covers searches. You've just invoked your Fifth Amendment right. The officer nods and says, okay, that's fine, but I'm going to need to take a look in your vehicle. Step out, please. Most people comply, thinking, well, he's the police, he can search if he wants. Wrong. People confuse Fourth Amendment rights with Fifth Amendment rights. These are completely separate. Why people make this mistake? They assume invoking one right protects everything. It doesn't. The legal reality under the Fourth Amendment, police need either probable cause, a warrant, or your consent to search your vehicle. If they're asking permission, they don't have legal grounds to search without your consent. Refusal to consent cannot create probable cause. The Supreme Court was clear on this in Florida versus Bostick. The evidence problem: if you consent, even reluctantly, anything they find is admissible. Body cam shows you said, okay, or I guess, and courts interpret that as voluntary consent. The officer psychology: they ask for consent specifically because they don't have probable cause. The request itself proves they need your permission. Training materials teach officers to phrase it as a command disguised as a request. I'm going to search your car now, or step out. I need to look inside. It sounds like you have no choice, but legally, you do. Dialogue exchange. Officer says, I'm going to need to search your vehicle. You hesitate. He adds, unless you've got something to hide? You say, no, I don't have anything. He hears cooperation and starts opening your door. You didn't consent, but you didn't refuse. And courts often interpret ambiguous responses as permission. The correct move? When the officer requests to search, you say, I do not consent to any searches of my person or my vehicle. Say it clearly, firmly, but politely. The exact wording matters. Do not say, I'd rather you didn't, or do you have to? Those are questions, not refusals. Say, I do not consent. Present tense, definitive. Why this works: under Schneckloth versus Bustamante, the government must prove consent was freely given. If you clearly state you do not consent, there's no consent. If they search anyway, any evidence may be suppressible. Critical tactical point: if they had probable cause, they'd search whether you consented or not. So refusing consent costs you nothing when they have grounds, but protects you completely when they don't. If the officer says, I don't need your consent, I'm searching anyway, you respond, I do not consent to this search, and I want that noted. Then comply physically. Do not resist. Your verbal objection preserves your Fourth Amendment rights for your lawyer to challenge later. Wrong way. Officer says, can I search your car? You say, well, okay, I guess. He searches, finds gym bag with friend's prescription pills. You're arrested. The consent was voluntary on body cam. Right way. You say, I do not consent to any searches. He cannot search without probable cause. If he searches anyway, your lawyer files a motion to suppress. That's the bottom line on Fourth Amendment search refusal. That protects your Fourth Amendment rights. But prosecutors need verbal admissions plus physical evidence, plus your failure to invoke Sixth Amendment protections. When you refuse consent, you've blocked the physical evidence. But mistake number 4 is not securing legal representation. Phrase number 4 is, I want a lawyer, and I'm not answering questions without one present. After you refuse consent, the officer shifts tactics. The smile fades. He says, okay, that's your right, but I smell marijuana. That gives me probable cause to search. Before I do, is there anything in this car I'm going to find? Most people think they're in trouble now. They think he's searching anyway. Maybe I should just tell him. Wrong. The mistake: answering questions after refusing consent, thinking the lawyer thing only applies if you're arrested. Why people make this mistake? They think requesting a lawyer makes them look guilty. They think it's only for interrogations at the station, not roadside questioning. The legal reality under Miranda versus Arizona and Edwards versus Arizona: once you invoke your right to counsel, all questioning must cease immediately. This applies even during traffic stops. The moment you're detained and subjected to interrogation, Miranda protections apply. The evidence problem: without a lawyer, you have no one protecting you from improper questioning, lies about evidence, or psychological manipulation. Body cam shows you alone, facing a trained interrogator, making decisions under stress. Officer psychology follows the Reed technique. After you refuse consent, they often claim probable cause anyway. Then they offer what seems like a last chance to cooperate. They're trained this moment of increased pressure is when people crack and admit things they otherwise wouldn't. Realistic dialogue. Officer says, "I smell marijuana. I'm searching the car. Is there anything you want to tell me?" You panic and say, "I smoked a joint like 2 days ago, but there's nothing in the car now." He writes that down. You just admitted drug use. At trial, the prosecutor uses that admission even if they find nothing. Correct response. You say, "I want a lawyer, and I'm not answering any questions without one present." Questioning stops. Anything he finds during the search is admissible if he truly has probable cause, but you've given zero verbal admissions. The correct move? "I want a lawyer, and I'm not answering any questions without one present." The specific wording matters. Under Davis versus United States, your request for counsel must be unambiguous. Don't say, "Maybe I should talk to a lawyer." That's ambiguous. Courts have held officers can continue questioning after ambiguous requests. Say, "I want a lawyer." Clear. Unambiguous. Why this works. Under Edwards versus Arizona, once you invoke your right to counsel, police cannot reinitiate interrogation. Only your lawyer can waive this right. Tactically, it signals further attempts to interrogate will result in suppression of evidence. If the officer says, "A lawyer? What do you need a lawyer for if you didn't do anything wrong?" You say nothing except, "I want a lawyer." Do not explain. The invocation stands alone. Wrong approach. Officer says he smells something. You start explaining, "I swear there's nothing in there. My friend might have smoked in my car last week." You've given him timeline, associated persons, and admission drugs were in the vehicle. Right approach. You say, "I want a lawyer, and I'm not answering questions." Your lawyer handles everything from this point forward. That's the bottom line on invoking Sixth Amendment right to counsel. You've invoked Fifth Amendment silence, refused Fourth Amendment searches, and demanded Sixth Amendment counsel. But there's one command officers can legally give that you must obey, and refusing will get you arrested. Pennsylvania versus Mims established this. Phrase number 5 is how you comply while protecting yourself. Phrase number 5 is, "I am complying under protest to preserve my Fourth Amendment rights." The mistake is thinking you can refuse to exit your vehicle. You've invoked all your rights. The officer, no longer smiling, says firmly, "Step out of the vehicle." Some people refuse. They think, "I don't have to follow orders. I know my rights." Wrong. This is the dangerous mistake that turns a traffic stop into an arrest. Why people refuse? They think exiting is the same as consenting to search. It's not. The legal reality from Pennsylvania versus Mims. During any lawful traffic stop, an officer can order you out without any additional suspicion or probable cause. This is for officer safety. The Supreme Court held that the intrusion on your liberty from stepping out is minimal compared to officer safety concerns. If you refuse, you can be arrested for obstruction or failure to comply with a lawful order. The evidence problem: if you physically resist or refuse to exit, body cam shows you being uncooperative, which prosecutors use to paint you as someone with something to hide. It undermines every right you properly invoked. Officer psychology. After you've invoked your rights and refused consent, ordering you out reasserts their authority and creates an opportunity for a protective frisk if they can articulate reasonable suspicion you're armed. Realistic exchange. Officer says, "Step out of the vehicle." You say, "Why? Am I under arrest?" He says, "No, but you need to step out now." You refuse. He repeats, "Step out or you're arrested for obstruction." You comply, but now flustered. And when he asks you to empty your pockets during a frisk, you do so without thinking and pull out something incriminating. The correct move. When ordered to exit, you say, "I am complying under protest to preserve my Fourth Amendment rights." Then step out slowly, hands visible, stand where directed. Why this specific phrasing works. Under MIMS, you must comply with the exit order. Refusal is not protected. But by stating you're complying under protest, you preserve your ability to challenge the legality of the order later, if it was pretextual. You're creating a record on body cam that your compliance was compelled, not voluntary. This matters for suppression motions. By specifically mentioning Fourth Amendment rights, you're signaling you understand this is a seizure and you're not waiving protections. If the officer then says he's going to pat you down for weapons, you say, "I do not consent to any searches, but I will not physically resist." You keep hands visible. You allow the frisk, but you verbally objected, which preserves your rights. If he goes beyond a frisk for weapons and starts emptying your pockets, you say, "I do not consent to this search." Your verbal objection is on body cam. Wrong way. Officer orders you out. You refuse. He pulls you out. You resist slightly. You're arrested for obstruction. Right way. Officer orders you out. You say, "I am complying under protest to preserve my Fourth Amendment rights." You exit calmly. He orders a frisk. You say, "I do not consent to searches, but I will not physically resist." The stop ends. You preserved every constitutional protection. That's the bottom line on complying with lawful orders while protecting your rights. Here's the core principle. Constitutional protections are not self-executing. You must invoke them explicitly, clearly, repeatedly. These 5 phrases do that. Let me remind you of them. Number 1, am I free to leave? This establishes your legal status. Number 2, I invoke my right to remain silent. This protects your Fifth Amendment rights. Number 3, I do not consent to any searches. This protects your Fourth Amendment rights. Number 4, I want a lawyer, and I'm not answering questions without one present. This invokes your Sixth Amendment right to counsel. Number 5, when ordered to exit, I am complying under protest to preserve my Fourth Amendment rights. Here's your practical next step. Write these 5 phrases down. Put them in your glove box. Practice saying them out loud until they're automatic. When an officer smiles and starts that friendly conversation, you'll know exactly what's happening and exactly what to say. Remember, this is educational content only, not legal advice. For your specific situation, consult with a qualified attorney in your state. If this video helped you understand your rights, hit that like button, subscribe for more legal education, and turn on notifications. You just learned the legal framework for traffic stop interrogations. But there are other constitutional protections that work differently in different situations, and most people invoke them incorrectly. I break down those other legal protections and exactly when each one applies in the next video. It's the rest of the constitutional framework you need to understand. Watch it right here on screen. And let me know in the comments where you're watching from and what time it is right now. Knowledge is power, but only if you use it. Stay calm, stay polite, stay protected.